Today's case is a few years old, but it's a concise example of how a motion for a directed finding in civil cases operates in Illinois. But first, this message.
Hey, thanks again for visiting my channel. If you like the content that I produce, feel free to hit that subscribe button and turn on notifications.
In today's case, mom leaves with the child. Dad files a motion under the old Parentage Act seeking to have said child returned. Now keep in mind, at that point, parentage and custody haven't been established yet. And Section 13.5 under the old law, which is now Section 502 under the new law, does allow a judge to enter an injunction stopping someone from leaving the jurisdiction of Illinois with the child until there's been a formal parentage or custody termination. So at hearing, Dad lays down his claim at the close of his case in chief at the injunction hearing, but before Mom can begin hers, she moves through what's called a directed finding, stating, hey, I know the statute says that the judge can stop me from leaving, but here's kind of the rub. I already left well before Dad filed this, and there's nothing in the statute that says that the judge at that point can order the child back. The judge kind of purses through the statute, kind of reluctantly agrees, grants the directed finding, and at that point, Dad appeals. First, motions for directed findings in civil cases are kind of rare birds. Basically, you're saying as soon as the plaintiff has finished their case in chief, you're going to the judge and saying, hey, judge, they didn't put on enough evidence to prove whatever it is that they're trying to prove. We're wasting our time with me having to put on my case in chief. Let's just end it right here. So what the judge does is first, they're going to look at each element of whatever it is they're trying to prove and see if some evidence has been put on. And then the next thing they're going to do is they're going to kind of weigh all the evidence that has come into that point to see if, based on that, we can go anywhere with the plaintiff's case. If the plaintiff hasn't put on enough evidence, the court can actually enter a directed finding at that point, which ends the case and the defendant wins. Here the appellate court says, we've already covered this ground in a previous case, and the scope of the injunctionatory relief under the statute does apply to cases where a parent with child has, kind of flown the coop before an injunction motion under Section 13.5, now Section 502, could be filed. So the fine is reversed and is remanded back for further determination. Anyways, that's all I have. Thanks for watching.